Hi, this is Robert Perkins, the Immigration Professor, and this is part 2 in my series about immigration based on marriage. And so you can see all my videos on my website, which is www.immigration-professor.com, or please call us about any specific questions regarding your case, or if you need representation. We have offices in Illinois and California, and we represent people from all different countries all across the United States. You can reach us at 310-384-0200. So in part 1 of this series, we talked a little bit about marrying someone from another country who came legally. Either their visa had expired, but they came legally, or their visa hadn't expired, and what that process involved. Today I'm going to talk about the special problems that are involved when someone came illegally and you're marrying someone who may have come illegally. What do you do? Because the law does have some penalties for people that came illegally. So the first question that I always ask clients, or always sort of analyze in a case is, can we process this person's petition in the United States? Can we process their case here? And there's a law that that might allow us to do that for people. It's a law that expired called Section 245I, and it actually expired April 30th of 2001. So, but people ask me, Professor Perkins, how can you actually help people based on a law that expired? Well, the nice thing about Section 245I is that it has what we call grandfathering petitions, grandfathering provisions, and it doesn't necessarily relate to someone's grandfather. What it means is that certain people are covered under this law. And this law actually allows people that entered illegally to process their cases in the United States. And it's quite liberal. If the person had a petition filed for them, any kind of immigration petition, could be through family member, could be through a different family member, not their spouse, could be through a brother or sister, or perhaps a petition was filed for them through an employer. Even if that petition wasn't granted, even if it wasn't approved, as long as it wasn't frivolous, and it was filed on or before April 30th of 2001, that person is covered under this law. And what it means is that that person can process in the U.S. They actually have to pay a penalty of $1,000 more than the normal fees, but they can process. So the first question I ask someone that comes into my office and they've married someone who came illegally is, have you ever filed anything before? Has someone ever filed for you? Did someone ever file for your parents a petition that may have included you because you were under 21? So those are important questions to answer. So let's assume, so it's nice when someone is able to immigrate in the U.S., and if they are, the procedures for that are covered in my first video about marrying someone and processing in the U.S., because that illegal can then pay the penalty fee to process in the U.S. But let's say they can't. Let's say they've never filed anything, and that happens quite often. What happens then? Well, it's a two-part process, basically, that needs to happen. First, the husband or wife has to file a marriage petition here in the U.S. It's called an I-130. And it takes roughly about 1 year for that petition to be approved. And basically they just have to show that they're legitimately married and they live together and so forth. So the first part is just filing that. And the second part of the process is an embassy interview. Okay, so they actually have to process outside the U.S. And the problem becomes that because the person came illegally, and if they have been here illegally more than 6 months, they have to get the government to waive, what we call a waiver, could also be understood as a pardon, The government has to pardon the fact that they were here illegally. And that's tough to do sometimes. The standard for a pardon is they have to show an extreme and unusual hardship to the wife, or husband, the spouse, parents, or child that are citizens or permanent residents. So they have to show some kind of hardship to their immediate relative to be able to get a pardon. So let me give you an example of some cases that I've had. I had clients that come into my office. The wife's a citizen, the husband's not. Husband came illegally. They're 22 years old. They just got married. They have no kids. They have no medical conditions. Husband came illegally. Can the husband immigrate? The question is probably not. When I'm looking at a case, what I look at is, yes, they can file a marriage petition. Yes, they can show that they're legally married. However, what will happen is they have to go outside the U.S. to the embassy. And when that happens, they have to get a waiver or pardon of the fact that they've been here illegally. And since the couple I mentioned was 22 years old, has no kids, no medical issues, no financial issues, they're not going to be able to show some sort of hardship to the wife if the husband isn't allowed to immigrate. So it can be really hard when you marry somebody that comes illegally. One thing I want to mention is about these waivers or pardons that the U.S. government and embassies in Mexico are much nicer about giving these pardons than in other areas of the world. So when I'm analyzing a case, or when a client comes into my office, let's say the client comes from Romania, just as an example. I may not take the case because unless the hardship case is so extreme, an example of that would be that the U.S. citizen is on, can't go to Romania because they have cancer that can only be treated in the U.S. That would be a pretty extreme hardship case. I probably wouldn't even take the case. So it's really hard to get a waiver. However, extreme hardship can come in a variety of forms. We did a case recently, for example, from Mexico where it was a husband, he was 60, marrying a wife who was 40, and the husband had lost 2 previous wives that died on him and had some psychological hardship, and that was an important factor in getting a waiver. Again, a waiver is hard. The person actually has to wait outside the U.S. for up to maybe even a year, waiting for an answer as to whether this waiver or pardon will be granted. So the bottom line is it's much more difficult to immigrate based on marriage when the person entered illegally. But it is possible. It's always good to get your case analyzed by an immigration lawyer such as myself. All my videos are available on my website, immigrationprofessor.com, or call my office at 310-384-0200. Thank you very much, and I hope to see you soon.